Good afternoon. My name is Currie, and I'm the Deputy Executive Director and Counsel for ConsensusDocs. I want to thank you for participating in today's 90-minute webinar. Today you're going to learn about geotechnical consultant agreements using the ConsensusDocs 246 as an example. Just a couple of housekeeping items. A few days after the webinar, you will receive an email with a link to the recording of this webinar, as well as a copy of the PowerPoint presentation. Also, for today's webinar, you'll have an opportunity to ask questions of our speakers. Please type your questions in the questions box, and we'll address them at the end of the presentation. I would now like to introduce our esteemed speakers, Phil Beck, Robbie MacPherson, and unfortunately, Bob Stothoff was unable to join us today after all. But we're lucky to have Phil and Robbie. Phil is a partner in the Atlanta office of Smith, Currie, and Hancock, a nationally recognized construction law firm where he has practiced since 1981. Phil chaired the working group that drafted the ConsensusDocs 246. He has experience with a broad range of construction issues from a wide variety of projects, both public and private, throughout the United States. He has drafted, reviewed, and negotiated hundreds of design and construction contracts and tried cases before numerous forums. Phil also writes and lectures extensively on a variety of construction law topics. Robbie is a partner at Gibbons Law PC in its New Jersey office. He is a fellow of the American College of Construction Lawyers and former chair of the ABA Forum on the Construction Industry. He has been practicing construction law since 1981, regularly acts as a construction contract and disputes counsel for contractors, subcontractors, suppliers, and owners involved in building and heavy civil construction for public and private work. Robbie teaches construction law at Rutgers Law School and also acts as a mediator and arbitrator for the industry. We're very lucky to have such prominent construction industry professionals for our presentation today. I'd like to start with a very brief overview of ConsensusDocs, and then we'll get right into the substance of our webinar. As you may know, ConsensusDocs is a coalition of 38 leading design and construction industry associations. What's been going on since our launch in 2007? Well, our coalition has increased by more than 80%. As I just mentioned, we're now up to 38 coalition members. We've experienced consistent user growth despite a down economy. We have more than 100 contract documents that address all methods of project delivery. And we were the first in several areas. We were the first IPV contract, the first BIM contract, the first comprehensive green building contract. One of our philosophies is to remain up to date with best practices and leading trends. So in 2011, which is a little bit in advance of our 5-year regular update schedule, we did a comprehensive update to primary agreements to make sure that your contracts were up to date with what's going on in the industry today. And probably most exciting recently was in 2012, just several months ago, we released an entirely new technology platform. This platform is in response to user requests that we make the documents easier to use and collaborate. So the documents are now in Microsoft Word, and you can edit and share those documents via our unique collaboration platform that helps you with version control and many other useful tools. And one of the new contracts in this new platform is the 246 Owner and Geotechnical Consultants Agreement. I'd now like to turn it over to Robbie and Phil.
Thank you, Currie. This, as you can probably tell by the accent, this is the Georgian on the panel. You'll hear from the New Jerseyan next. I'm happy to be with all of you today, albeit by computer and telephone, and appreciate that very kind introduction, Currie. I want to talk with you a little bit here at the outset about what the document is and was intended to do, and then I'll let Robbie get into some of the details of the organization of the document. Obviously, the 246, the ConsensusDocs 246, is a document designed to be used by an owner who is engaging a consultant to perform geotechnical services. As the title of this program today suggests, what lies beneath, or what lies beneath the surface can be an extremely important thing for the construction project. It may not be visible to laymen, It may not be something that appears in the final product, but it has an awful lot of impact on the project itself. And for that reason, we think it's very important that the foundation of the project begin with a good foundation contractually. The need was perceived for a consulting agreement designed specifically for geotechnical services. That need was presented to the ConsensusDocs Content Advisory Council, which is the group that controls the content of the documents, of the ConsensusDocs documents, subject, of course, to the approval of the various collaboration partners. And that group, upon agreeing that it was a worthwhile endeavor, commissioned a working group to create the document. And Robbie and I both had the honor of serving on that working group. Once we had completed our mission, and let me say a little bit about that, we did have a diverse group involved in that process. We had geotechnical consultants involved, as well as a number of attorneys and construction professionals, so that we could listen to the views of all aspects of the industry. We developed a document that we felt met the need that we were trying to address, presented that back to the council for approval, and upon receiving that approval, it went to all the coalition members for their ultimate approval of the document, and the end result was the document that was published in June of this year. As with any form contract document, one of the benefits for using a form is its predictability, is the fact that the parties can know the basic ground rules from project to project. But also, as with any form, there is a great need for flexibility. Not all, even if you limit the universe of contracts we're discussing to geotechnical consulting agreements, not all agreements, it's not a one-size-fits-all, and we recognize that. And we've tried to build into the document flexibility on things, even things as basic as the basis of payment. As you know, a lot of geotechnical consulting agreements, or as many of you know, I suspect, some geotech consultants may be working on a flat fee, some may be working on an hourly fee. There are all types of permutations of that, and we've tried to build the flexibility into the document that would allow the parties to address that, both in that areas as well as others. As Currie has already mentioned, some of the fundamental philosophies behind ConsensusDocs, we've tried to carry those through into the 246. We've tried to create a fair and balanced document. I believe we've accomplished that. We've tried to make as the document clear and understandable, written in plain English, which is a challenge given the number of us attorneys that were involved in the process, but I hope we've accomplished that as well. And finally, as with all ConsensusDocs, we've tried to create a document that advances the best interest of the project as a whole and the team as a whole, not an individual participant. And I hope you'll agree that we've accomplished that as we get into some of the details of the documents. The final thing I'll say, and then I'll turn it over to Robbie, is that you will find in this document some provisions that you probably are not accustomed to seeing in geotechnical consulting agreements, because we've tried to stay true to ConsensusDocs, and we've tried to adopt what we believe to be the best practices in the industry. And some of those are things that go beyond what a more traditional geotech consulting agreement might cover. With that, I'll turn it over to Robbie to get into some of the details of the structure of the document.
Thanks, Phil. Not for nothing, but those of us in New Jersey don't normally talk about accents because we don't think we have them. Before I get into the substance, let me talk a little bit about the working group, and really for this point. For those of you that are involved in construction contract drafting or negotiating, you want to get yourself on one of these committees that reviews the ConsensusDocs, especially the new docs, and gets involved in the process of drafting them. There is no better experience you can have that'll teach you how to draft and negotiate contracts and sharpen the skills you already have. So that's a plug for volunteering for the Contract Documents Committee. What we have up on the screen is the table of articles. And as you note, this table is very clear, it's very concise, and that's what you're going to find about the ConsensusDocs 246. You'll also find that this table is a really good summary of what's in the agreement and where to find it. One of the things that I find is there's a tendency of some when reading contracts to focus on articles like Article 3, the consultant's responsibilities, and Article 5, the owner's responsibilities, where the meat of the document is. I think that's a mistake. I think you need to look at the entire document and every clause, and especially spend time on what some of the clauses that are called boilerplate but have no less importance than the other clauses. And I think you'll find that every clause in this agreement has an important purpose and is in the agreement for a specific reason. Some clauses are, of course, more significant than others, and we're going to focus on many of those clauses that are more significant and have made more of an impact on the relationship between the parties. Next slide, Phil.
Thank you. One of the ways that you build flexibility into a form and allow the form to be adaptable to the needs of a specific project is through exhibits. At least that's one of the ways we've done it in this document, and I think allows the document to be used with minimal modifications. So what you have on this slide is a list of those exhibits. And this list, by the way, appears in, as it indicates, 2.2.1 of the document, because as you would expect, each of those exhibits is incorporated by reference as a part of the contract itself. Exhibit A is the list of, is the description of the services that the consultant is going to provide, the scope of services, if you will. Obviously, that's a key aspect of any contract, but one that is going to vary significantly, so we've addressed it through an exhibit. Exhibit B is a list of deliverables. Having written and negotiated a lot of consulting and design and other types of contracts, as well as construction contracts over the years, I find that I think the more sophisticated owner clients like to have the contract spell out exactly what it is they're going to receive in terms of a deliverable from their consultant. And I think that minimizes the likelihood that you will have disputes because of differing expectations. So what we have done in the 246 is to include an exhibit which calls for the parties to identify those deliverables, what I refer to as deliverables, the reports and other documents that the consultant is to produce for the fee. Exhibit C is a list of owner-furnished project information. I'm going to talk more about that later, so I'll defer that for now. We also have an insurance exhibit. And then finally, Exhibit E is the fee schedule. As I alluded to earlier, the method of compensation can vary significantly for geotechnical consulting contracts. In fact, I've seen, and I suspect some of you have seen, geotech agreements where a single agreement may be a combination of a fixed fee for a certain scope of services, perhaps a unit price fee for another aspect of the service, and hourly fees for yet another, and perhaps cost reimbursable for yet a fourth category. What we've tried to do by making the fee an exhibit is to allow the parties the flexibility to make the contract fit whatever the needs of that project and the needs of those parties may be. Let's go to the next slide if we could.
Okay, we're going to talk about standard of care. What is a standard of care? Very simply, the standard of care is how will the performance of the consultant be measured? And what the contract sets forth is the criteria against which the consultant's performance will be measured. Generally, the consultant will be providing a professional service and must bring professional skills to the table. Now, what are those skills? Well, they're going to be determined by the type of project and where and when it will be constructed. A larger, more complex project will require a greater level of skill, obviously. A project in a densely populated urban area will require different skill sets than would work on a greenfield site in a rural area. Work done under time access restrictions will require experience in that type of work. For example, in many urban areas, working on highways in the urban areas can only be done in the evenings. So if a consultant is doing geotechnical work on a highway that can only be accessed in the evenings, they're going to have to be experienced in working in the evenings and working in those types of conditions. One of the most important things to keep in mind is the consultant is only responsible for its own work. It is not responsible for the work of others unless they are sub-consultants to the consultant. And lastly, under the standard of care, also addressed in this article is safety. Most consultants may be used to the fact on a project that the general contractor is responsible for site safety, overall site safety. This agreement assumes that at the time the consultant is working, it's probably going to be the only person on site or one of very few on site, and it makes the consultant responsible for the safety of those on site while the consultant's operations are ongoing. So that might be a little different than the consultant is used to, and attention should be paid to that. We can go to the next slide.
Super, Robbie and Phil, I just wanted to break in and let you know that Bob Stothoff has been able to join us. We have a little bit of technical difficulties. So, Bob,
finally here.
Wonderful, thank you. I'll go to the next slide and let you all.
Sorry about that.
Thank you, Currie. Welcome, Bob. This next issue that I'm going to address, and I'll invite Bob to add anything he may want to add particularly from a consultant's point of view. You might not guess this at first blush, but this topic of site damage actually was one of the topics that received quite a bit of discussion and debate within the working group, I would suggest that the reason that is fairly simple, and that is that, like some of the points that Robbie was just discussing, that what is reasonable to expect in terms of any site damage caused by a consultant and any site repair of site damage which may be expected of the consultant is going to vary considerably depending upon the locale, the nature of the consulting services being provided, the nature of the site, and a variety of other factors. What you would expect the consultant, whether you would expect the consultant in performing its work to create a natural byproduct of some damage to the site or not, will depend, as we lawyers like to say. And whether that consultant should have any responsibility for correcting that damage will also depend upon a variety of factors. What we ended up with was actually, believe it or not, a very short provision, and it's so short, let me read it to you because I don't know if any of you have the document in front of you. 3.9 site damage simply now reads in its final version, the consultant shall take reasonable precautions to minimize damage to the site. However, the owner recognizes that in the normal course of the services, some damage may occur. And that's it. I know that a lot of non-lawyers don't like that word reasonable being in the contract because they're not sure what it means. But we lawyers know that the reason it's in the contract is because the meaning will depend upon a variety of circumstances. And again, as with any form, we need to have that flexibility. So that is how we ultimately resolve that issue. We think it's a fair and balanced provision that is admittedly a little bit open to interpretation. And to the extent a particular contract requires for more definition in that area, obviously the parties are free to modify the contract to meet that need. But that's how we ended up with where we are. I think from an owner's point of view, it is a reasonable approach that allows some flexibility. And unless Bob, do you want to address that from the consultant's viewpoint, or should we go to the next?
No, I would just briefly, from a consultant and/or contractor standpoint, reasonable may not be the best term, but it does take a lot of ambiguity out of, going into a project what, should or should not be expected for, reestablishment of the site if there's any damage. So it's a very good give and take that, we all, discussed quite a bit to make it a practical solution. It's probably the most practical wording of any site damage document that I've ever come across. So I think it's the work that we did makes it very short and simple and to the point. And again, if there is anything certain site requirements or peculiarities about the site, that all can be addressed and addended to it. So I think it's a short and sweet, but it makes a good point.
And I guess we're ready for the next slide. Okay.
Okay. There'll be extra credit for anyone that can get the reference to the top quotes. So just send in your comments, and we'll see who gets the credit. 3.10 time is kind of unique, I think, in a lot of consultant agreements. The first sentence says, all services required by this agreement, including delivery of all reports to the owner, shall be completed within blank days of the date of this agreement, time being of the essence. So the consultant is not given a time within which, general time, it has to deliver its work by a specific date to the owner. And what does time of the essence mean? Well, what it means is close enough is not good enough. If your reports are due on May 1st and you deliver them on May 15th, you are in breach of contract. If you deliver them theoretically on May 3rd, you are in breach of contract. So the consultant needs to be aware that when it signs an agreement with time being of the essence, it means what it says, and you've got to comport with those time requirements. Why is it in there? Well, this is very important to the owner, this information from the consultant, to get it as early as possible so that the rest of the project can proceed. And the consultant needs to be sensitive to the owner's time constraints. I think it's an issue that the consultant needs to discuss with the owner during contract negotiations. Are the times reasonable, or if they're not, suggest different times. But just don't assume that you're going to get an extension. The clause does provide that the consultant will get time extensions for reasons beyond the consultant's control. The acts and omissions of the subconsultants are considered to be within the consultant's control, so that if your equipment does not arrive on site because your equipment rental company didn't get it there, the owner is going to hold you responsible for that. So you need to coordinate that activity. There is also a duty under this clause of the consultant to mitigate any delays. And mitigate delay means that the consultant has an obligation to take affirmative action, if they can, to limit the impact of delays on the overall project. Finally, the clause provides for adjustments, what we call equitable adjustments, in the event that the consultant is delayed, and those adjustments could be for both time and fee. And what does that mean? A good example is that if the consultant is on the project longer than anticipated, they may be able to recover additional rental of equipment that had been on the site longer due to an owner-caused delay. Bob, do you want to add anything?
No, it's again, having that clause that if the consultant and/or subconsultants are delayed because of issues arise because of the or from the owner, then at least we on the consultant and subconsultant side have a means to recoup any of those costs if there should be any. Again, it's something that is new, or at least I feel is new, that you don't normally see. So it's another good thing that we've worked on.
And I think the consultant can look at this as a selling point to the owner. You know, we're going to provide these services, and we're going to provide them consistent with your schedule so that your project moves forward, and we're willing to do that, make that commitment. We can go to the next slide.
Thank you. This is Phil again. I'll address this issue of hazardous waste. This was actually, believe it or not, another provision that received considerable attention and discussion within the working group. And unlike the last section that I made that comment about, where the end result was a very short provision, here we went the other way and came up with a very lengthy provision. In fact, in a document that is only about 16 pages in length, almost a full page of that 16 pages is devoted to this one provision, section 3.12. One of the things I learned early in my 30-plus now year career as a construction lawyer is that when it comes to hazardous waste, contractors can be, or any type of hazardous material for that matter, contractors can be generally grouped into two categories. Contractors that make their living dealing with environmental hazards and hazardous materials, and everybody else who should stay as far the heck away from it as they possibly can. I think the same is true of consultants. Within the realm of geotechnical consultants, then you're dealing with both consultants who are retained for the express reason that there are hazardous materials that need to be surveyed, cataloged, identified, quantified, located, and therefore must embrace and deal with hazardous waste in the performance of their services, to the other extreme of consultants who don't expect to encounter hazardous waste and are not equipped, insured, and prepared to deal with them if they do. So what we've tried to do is address that very important topic, recognizing that it may be encountered in under a lot of different scenarios, depending upon the scope of services, etc. What we've tried to do in this provision, and the reason it took so many words to do it, is that we first of all try to define the term, because obviously what is hazardous may be in the eyes of the beholder. So what we've done is to adopt a specific legal meaning for the term, that being the term as defined by the U.S. Environmental Protection Agency. We've placed upon the owner the responsibility to disclose to the consultant any known hazardous waste on the site, and upon the discovery of any previously unanticipated hazardous waste, the consultant, if it's not within their scope of services to address that material, they are entitled to stand down, absent a mutual agreement to proceed, because we don't want to subject someone to that risk and that liability who didn't bargain for it. The owner maintains the responsibility for testing unanticipated material and to try to minimize the effect of that on the consultant's work. As Bob mentioned earlier with regard to the element of time, the document in this area also recognizes that a consultant may be entitled to an equitable adjustment of their contract price or time, and perhaps indemnification from the owner, depending upon the nature of the materials encountered. We also note that under certain circumstances, material safety data sheets may need to be maintained. And then we finally, we do address the consultant's responsibility for the proper handling of any materials that they introduce to the site, so that responsibility stays with them. So what we end up with is a fairly lengthy but thoughtful provision that tries to address the subject of hazardous waste from all angles. We received a lot of industry input, a lot of technical input on this provision, and feel that it is a good provision that meets the needs of the project and the needs of the parties. I think, Bob, if you have something to add, please do, or otherwise we can move to the next slide.
Yeah, the only thing I would start to mention is, the clauses that we, or the, language that we have in here does, lend itself very well to, especially in the, revitalized to urban areas, brownfield sites, things like that, where, I guess rebuilding of these areas are, usually done. It gives us enough information that, if there is something encountered, on a site like this that was unanticipated, there is the, not necessarily the out, but there's a, very clear understanding of what the sub-consultants do and do not need to do. And, it just gives, it balances everything very well, in my opinion.
Okay, ownership of documents. This is a clause that you probably see more often in architects' agreements, but it really is a very important clause for all who create intellectual property. And it's probably a good point here to talk a little bit about property rights and copyrights and the distinctions. A property right is the right of ownership in a physical thing, such as a drawing. We all have property rights in the CDs and music files that we buy. See, I use music files to show that I'm not totally behind the curve. A copyright or a patent is a right in the intangible asset. And it is what they call this bundle of rights that we'll talk a little bit about. As the owner of music that you've purchased on a CD or a file, you really don't own the music. You only own a limited right to use that music. For instance, you can play it for your friends and your family, but you can't decide to have a movie party at your house and get $1 at the door and play movies and music for people. That would be a copyright infringement. The issue that arises under design contracts, or contracts like this where intellectual property is going to be created, is who is going to hold the copyright or the patents of the intellectual property that is created by the consultant's work product. And what we're talking about is this bundle of rights, which might include the right of reproduction or to incorporate some of the work product into another work. Now, what would be some of the derivative works that could come out of the consultant's work product? This is perhaps a little far-fetched, but it's not totally implausible. If the consultant does not retain its copyright to its work product, it would be prevented from perhaps publishing an article describing the work it did, or even perhaps making a movie if it was a very significant project. You never know. Discovery Channel, History Channel, they're all looking for very interesting projects to talk about, and if you give away your copyright to your project, you would not be able to take advantage of the fame and fortune that comes from being on a History Channel show. In most cases, consultants will want to retain the copyright to their work product, and in most cases, I think consultants will find that the owners are not really interested in the copyright. What the owner wants is a right, or what they call under the intellectual property laws, a license to use the consultant's work for this project, for expanding this project, for altering this project. But the owner doesn't want to use it for any other purpose. So most consultants will find that you're not going to have owners that require you to transfer the copyright. Under this document, it's a check the box as to whether the owner shall or shall not obtain the copyright. It's obviously something you got to pay attention to, but I think most consultants are going to find that most owners are simply not in it, interested in the copyright of the underlying work product. Once the owner does get a license, that license is dependent upon the owner paying for the work product, so that if there's a great incentive to the owner to pay and a great leverage for the consultant, if it doesn't get paid, that it can prevent the owner from using the work product, theoretically preventing the owner from going forward with the project. That might require an injunction to get, but it's a weapon that's perhaps available. If the consultant elects to transfer its work product to an owner, what rights does the consultant retain? Under the ConsensusDocs form here, and it's the case with most consensus design agreements, the consultant who transfers the copyright interest in its work product would retain the right to use constituent parts in later work. Now, what does that exactly mean? And let's look at the example of a design. The consultant, the geotech consultant, is engaged to not only do an investigation, but also to prepare the design for the foundation. However, the owner, for whatever reason, decides that it wants the copyright in that foundation design. If the consultant transfers the rights under the ConsensusDocs agreement, but retains the right to use a constituent parts, then the consultant would be permitted to use certain details within his foundation design on subsequent projects, but could not use the entire foundation design for this owner for which the copyright had been transferred. So an important clause provides important protections for the consultant and something that deserves attention during the negotiation of the contract. Bob?
I think you covered everything there, Robbie. It does, break down that, you can maintain the copyright, which is, obviously a good thing to have, and, it gives enough variation of, exchange of rights between the owner and the consultant for most of the information is going to need to be shared and used for design and construction. So I think it's all, I don't have much else to say about that one.
Before we get, this is Phil, if we could go back for just a moment, Currie, that last slide. If I may, I just would add a comment to echo what Robbie and Bob have said. I can tell you that particularly when you get into the design arena, that, again, having negotiated quite a few design contracts over the years, this is almost always an issue in dispute. I think maybe less so in the geotech consulting area than on the design side, but I think it bleeds over into this too. The fundamental debate being this: I mean, the owner's view is, I am paying you, Mr. Consultant, a fee to generate this work product, therefore I should own it, not only the property rights, but also the intellectual property rights that go with it, as Robbie has drawn that distinction very well. Whereas the consultant says, but I am the one that created it based on my years of experience, and it is in large part based upon things I have learned over the years, approaches, techniques, details I have developed over the years. So you are not paying me enough of a fee to acquire all the intellectual property rights to my work product. So it is an important point. It is a it may perhaps less so in the geotechnical arena than in others, but it applies here as well. And it did receive a good bit of attention for that reason. I think Robbie and Bob's done a good job of summing that up. If we can go to the next slide now, one of the ironies in the construction process, it has always seemed to me, is the fact that most owners go to great pains to select the general contractor or the construction manager who is going to build their project, but have very little involvement in selecting the subcontractors that will perform under that general or CM, when in reality it is the subcontractor that is going to perform the bulk of the work. It's the analogy that I have used on occasion that may offend some, I hope not, is that if I booked a flight on Delta Airlines and went to the gate and there was some ragtag plane sitting at the gate, and I asked them why that wasn't a Delta plane, and they said to me that is our subcontractor that we've hired for this flight. That's not meant as a slam against subcontractors. I represent quite a few of those as well, but rather to make the point that the owner has an interest not only in who its contractor is going to be, but also who their subcontractors are going to be. And that is true when you enter the consulting arena as well, whether it's geotech consulting services or other types of consulting services. The contractor has selected that geotech consultant based on their reputation, the owner's prior experience with that consultant, or perhaps a recommendation of someone they trust, or perhaps a variety of other factors. But what say should they have in any sub-consultants or subcontractors that are employed to work under that consultant? What we've tried to do in 4.1 of this document is to address that issue again in a fair and balanced way. We recognize that since it is the consultant that is ultimately responsible for the performance of those sub-consultants or subcontractors, that it is ultimately their right to choose who they're going to contract with. But we have given the owner the veto right to object to consultants, to subcontractors employed by the consultant if there is someone to whom they have a reasonable objection. Now, with that veto right goes certain responsibilities, at least under the 246. And in particular, it is an obligation to pay any incremental cost. If the consultant has selected someone and the owner says, no, I don't want you to use them, I prefer you use this other firm, and that other firm comes at a higher price tag, then it is the owner that pays that, because we felt, again, in a fair and balanced document, it wasn't appropriate to put that cost on the consultant. So we tried to balance it by giving the owner veto rights, but with a price tag attached to those veto rights. And then we've also got language in 4.1 that gives the owner the right to request that the consultant consider using a certain sub-consultant or subcontractor. But if the consultant has any reasonable objection to that party, the consultant cannot be made to use them. So there's no shotgun marriage, if you will, whereby a consultant is required to use the owner's cousin or nephew or someone that the owner wants to use that the consultant may have a reasonable objection to. Bob, any comments there from the consultant's point of view?
No, I think the best part is, how we worked in the owner's right to veto, and again, obviously the owner pays for that veto if, so chosen. So it does, as you just mentioned, it fits, wide, coverage of, what could happen when you do have a owner that, may happen to have a problem from prior experience with a, consultant's subcontractor. That does happen, and if, when it does arise, it's a very straightforward, simplistic way of being able to handle it. And it does, at least in these contract terms, it does, give you the opportunity to do so, where many other instances you don't have a choice. So it's, again, another thing that, we did put some effort into.
Okay, I think we're ready for the next slide then. Okay. Robbie, are you going to address utilities?
Okay. Yeah. Sorry about that. Utilities, as of past 15 years, I think it started back in New Jersey, where the one-call issue really came to light when the contractor unfortunately exploded a gas line, caught an apartment complex on fire. So since that time, there's been a lot of dedication to everyone, making sure that the consultant, subcontractors, even the owners, all have called out and have their, whatever their local utility, whatever the state utility system is. And again, we are, not only is it the consultant, but any contractor, by most state laws, is required. Whoever is doing the digging obviously needs to have their own separate ID number for that. And getting through it, if there is something that's encountered, it's brought back to the owner Because a lot of times when we do call in utility markouts, these markout firms do not come on the private property. So it gives a an upfront chance for the consultant to have discussion with the owner that with the recognition that once we do make this public call, that anything on site would have to be marked out either again by the owner or additional fees through the consultant. So I think it's pretty good language with it, best that I've seen so far.
Thank you, Bob. I think we lost Robbie lost his audio connection briefly. So, Bob, I appreciate your jumping in there.
No problem.
If Robbie has not reconnected yet, I'll just add that I think most states now have come a long way in terms of having a systematic mechanism for addressing locating utilities on a site, a call before you dig type procedure. I know we have that here in Georgia. We have that in most states I am familiar with. And what we've tried to do is to reflect that in the document, to require the parties to comply with that, and then also recognize or create an obligation on the part of consultant to take reasonable precautions to avoid any known underground utilities. So it is an issue. In hearkening back to our topic today, the title of our program, What Lurks Below, obviously one thing that may lurk below is utility lines that no one knew were there. So we've tried to address that in the document and to be fair and balanced in the way we put the risk on the contracting parties with regard to those utilities. If Robbie is not on or able to make additional comments at this time, why don't we move to the next slide, which deals with worksite information. And this is Phil. I will jump in there again. This section 5.5 gets into the whole topic of what the owner's obligations are to share information with the consultant about about the site. And obviously, or at least to us, it seemed obvious that the nature and extent of the owner's obligation needed to be broken down into two parts. One is the owner's obligation with respect to things the owner knew or had, and the second being the owner's obligation to generate new information. There is some, in my view, unfortunate case law out there. I'm aware of one case from 10 or 15 years ago out of the state of Texas. There are other examples, but case law that suggests that an owner can conceal from a contractor and presumably a consultant as well information that the owner has about the site. The case I am thinking of in Texas holds that it is incumbent upon the contractor as the construction professional to somehow discern what the site conditions are, even hidden or concealed or below the surface conditions, and that the owner has no affirmative obligation to disclose information about the site, even though it is known to the owner. Now, there is obviously conflicting case law there. I'm aware of a case out of Florida that comes to the opposite conclusion. But whether or not that is legally permissible, we do not feel, and I think I can speak for the owners who participate in the development of this document in saying that they did not feel that it is in the best interest of the project, of the overall project and all the parties, again hearkening back to that underlying principle of ConsensusDocs, for the owner to conceal from the consultant material information that the owner has that may affect the consultant's performance of their services. So what we've built into 5.5 is a duty on the part, an express duty on the part of the owner not to conceal available information. But at the same time, the owner does not have an unlimited obligation to generate new information. And in fact, the owner's obligation to generate new information to share with the consultant is limited to the information identified in the document. I referred earlier to an exhibit that we've created for that purpose. Section 5.5 also gives a list, a pretty extensive laundry list of the types of project information that may be appropriate for development and disclosure in particular circumstances. So we've got that in 5.5, that listing, as well as that division and allocation of responsibilities. And then I've thrown in the slide a reference to 5.6, which is a slight digression, but what 5.6 does is to also place on the owner an obligation to share with the consultant any information about the project site that the consultant might need if they find it necessary to file a lien to collect their fees, to share information about the property description. So, which is a little different type of information for a little different purpose, but yet another affirmative obligation that we've placed on the owner. Bob, anything you want to add on that, on the subject of worksite information?
No, I think at least from my point of view, it's a very extensive list that without having the owner do any new work or obtain any other information, this should all be depending on what type of site is being developed or work being done at. There should be within a few of these items that we have listed in 5.51. Should give a good basis of an understanding of the site and provide reasonable data that one would then be comfortable with realizing whether or not the task that they have at hand is going to be able to be done. So I think it's pretty good.
Okay, thank you. Let's go to the next slide, if we may.
I think so. Robbie, are you able to get back on?
Yeah, I am. Let's go back to 5.2, and then we'll then move on to the next slide. Real brief. The points I wanted to make, and I appreciate Phil and Bob pinch hitting while I had some technical difficulty. The obligation to locate and mark utilities obviously carries with it a very, very considerable financial and schedule risk. Especially the case you're dealing with gas lines and things, the potential for property damage, injury is great, and so great care must be taken. I think it's also important that the consultant understand that under this clause they have marking responsibilities, the owner has marking responsibilities, but the clause provides that no work is to start until all the marking and locating is done, and I think the consultant should assume that it is their obligation to ensure that they've done what they need to do and that the owner has done what the owner needs to do before they undertake any underground work. And the final point I'll make is that as fans of Zeke Moffett know, missed opportunity is not someone you want to miss. It's someone you always want to wait for, so do your homework, make those calls, and you'll avoid that risk and liability. Let's move on to indemnity, which is actually kind of a great segue here. What is indemnity? Well, indemnity, very simply, is an agreement under which you agree to protect someone else from third-party claims. Under the ConsensusDocs theory of sharing the risk and only placing risk on those that can control risk, the indemnity provisions in this agreement are of the more conservative type and are probably enforceable in most states. Many states have laws that make void and unenforceable indemnity agreements in which A agrees to indemnify B for A's negligence. Typically, A agrees to indemnify for B's negligence. You typically only indemnify someone for your own negligence, not their negligence. That's the ConsensusDocs theory, and the indemnity is only for your negligent acts, not the owner's negligent acts in the case of the consultant. What's also unique about the ConsensusDocs indemnity agreement is that it is mutual. The owner agrees to indemnify the consultant for the owner's negligent acts, and the consultant, which is more typical, agrees to indemnify the owner. You may find, if you're a consultant, that owners are not used to being asked for indemnities from their contractors and consultants. The more they use the consensus docs, the more they'll get used to it, and I believe that there is no real objection, there should be no real objection, to an owner giving a consultant an indemnity for the owner's negligent acts. Another important thing to remember about this indemnity clause is that it doesn't cover any and all claims. It is limited to claims by third parties for property damage, personal injury, or death. For the most part, this indemnity obligation is going to be insurable under your CGL coverage. An important thing for the consultant to keep in mind is that while your liability to your employees may be limited to Workmen's Compensation Acts, if the owner under a statute of your particular state is absolutely liable for the safety of workers on the owner's work site, and the owner can be sued by injured workers, that owner is going to want to, in turn, sue the consultant and request an indemnification. And in that case, the consultant's liability to the owner will not be limited by Workmen's Compensation, and in essence, you could end up paying your employee far more than they could recover under a Workmen's Compensation claim if you have indemnified the owner and your state allows such lawsuits. Okay, we can move on to the next slide.
Thank you. Let me talk about professional liability insurance for a moment, because when we're talking about geotechnical consulting services, we are talking about professional services. And as with any type of professional services, you've got a different type of insurance coverage in addition to the CGL coverage that Robbie just alluded to, excuse me. You've got a different type of coverage which the owner should request of the consultant, and that is professional liability insurance. It is particularly important in dealing with consultants, and I'm speaking now from the owner's perspective. It is particularly important that you ensure that the consultant have an appropriate level of professional liability insurance, because unlike some contractors or many contractors, most consultants, and for that matter most architects, don't have a lot in the way of physical assets. Whereas a contractor may be heavily invested in capital, may own equipment, etc. Usually with a consulting firm, you're talking about, and geotechnical may be on the higher end in terms of capital investment, but even for a very large architectural firm, for example, they may have an office lease and some computers and whatnot, but you're not going to have a lot in the way of physical assets. The significance of that is this: in the hopefully unlikely event that something goes wrong and the consultant errs in the performance of their services, resulting in damages to the owner, the owner's ability to seek compensation for that is very often going to be limited to any insurance coverage that consultant may have available. The ability to collect a judgment against a consultant even is likely limited to, or pretty close to limited, to their insurance coverage. And that's why we think it's important that the owner be mindful of that. Now again, depending on the size of the project, the extent of the services, the type of services, what is an appropriate level of coverage can vary significantly. So what we have in 6.5 is very much a check-the-box type approach. We introduce the subject of professional liability insurance. We have the affirmative statement that the consultant shall obtain professional liability insurance for claims arising from the negligent performance of any professional services under this agreement. But then in terms of the amount of the coverage, the deductible, the duration of the coverage, how long after the end of the project that coverage must be maintained, all of that is left to the parties to agree to and fill in the blanks, so to speak. One other important point to make about professional liability insurance for any on the phone that may not be familiar with that form of insurance, the standard professional liability policy is a practice policy, and it is a claims-made policy, so that if you could have $10 million theoretically, you could have $10 million of professional liability coverage, but if someone else beats you to that coverage, the professional may in effect have no coverage at all, at least no coverage available to you. So one of the other options we have included built into this form is the possibility of requiring project-specific coverage to ensure that there is coverage available for this project. So I've been involved in a number of projects over the years where the owner has elected to, for example, purchase a project policy that covers all the design professionals and consultants that are providing services on that project for that project, so that you have a dedicated policy available for that project. And that is an option that we're not necessarily recommending or dictate. Certainly not dictating, but we're raising the possibility that that is an option that the owner may wish to consider. Obviously, there's a price tag attached with that, and that's a call the owner has to make as to whether they want to purchase that level of coverage or not. So 6.5 is a fairly malleable, if you will, provision, but that does create an affirmative obligation on the part of the professional to provide this form of insurance coverage. Bob, anything you want to add to that?
No, I think it's a very practical approach to it, and and given the option of whether it be practice or project type coverage, gives it good flexibility.
I will say one other word about it. I mentioned that one of the fill-in-the-blank options is the length of the coverage, and the way that is worded is to say that the coverage shall be continued or in effect for a number of years after completion of the services. Again, keeping in mind that it's a claims-made policy, the claim may not arise and may not be reported to the insurance company until after, well after, in fact, the project is completed. So as an owner, one thing you want to do is to try to ensure that that professional keep its coverage in place after the project is complete. Now, the problem with that, of course, there is a very practical problem of how do you enforce that provision once the project is complete and the professional has been fully paid, particularly when you're talking about geotechnical consulting services that may have been performed on the front end of the project. How do you ensure that that coverage is maintained, even though the contract requires it? But we have at least created that affirmative contractual obligation and left it to the parties to decide how long that tail should be. I think we're ready for the next slide, and for Robbie.
Great. Okay, wonderful. I'll just add to this, to the insurance policy issue. To an owner, a project-specific policy may sound very attractive. The reality is that they are expensive and they are not always available. So don't take any comfort in the fact that you could check that box, find out is it available, and if it is, how much is it going to cost you. Mutual waiver, limited mutual waiver of consequential damages. Sounds like a mouthful, and every time I see this, I think of a modified limited hangout, which, as we all know, is the public relations tactic that President Nixon, H.R. Holderman, John Ehrlichman, and John Dean suggested could be used effectively to handle the fallout from the Watergate break-in. Now, what does that have all to do with limited mutual waiver of consequential damages? Not very much, but it seemed like a good lead-in. This clause, however, is a very, very important clause. It is something probably at the center of the consensus docs. and it is beneficial for all parties. It is good for the consultants. It is good for the owners. What does it do? Well, it's the reference here to $650,000 fee, $14.5 million judgment, refers to a case that came out of New Jersey. It was a casino project in Atlantic City. A contractor had been hired to oversee, really construction manage for a fee, a very, very large renovation of the casino. However, the contractor was on a really cost-plus basis in which it got no markup on subcontractor costs, and its fee was $650,000. The owner alleged that the casino was completed late. Strangely enough, the casino opened not too late based on the project schedule, but an ornamental entranceway that was intended to attract parties to the casino was not finished for several months after the official opening and the substantial completion of the casino. And in fact, the facts in the case were that the casino was substantially complete. The renovations were substantially complete. The casino was open and operating, and gamblers were coming in. However, the casino alleged that certain high roller rooms weren't completed, that more gamblers had come in, had the ornamental facade work been completed, and after an arbitration, the casino owner was awarded $14.5 million against the contractor, a good portion of which were for damages claimed to have occurred after substantial completion, consequential damages, lost gambling revenue. Shortly after that decision came down, you started to see these waivers of consequential damages in construction contracts and in design contracts. It's a good idea. The practical effect is that it limits your liability for direct consequences, but not every consequence of your act. And so that it really fits in with the balanced risk allocation scheme of the consensus docs. And I think everyone would agree that today is probably a standard provision in almost every construction and design contract. We can go on to the next slide.
This is Phil. In light of the very good and succinct tutorial that Robbie gave us all earlier on intellectual property rights, I want to be quick to admit and confess that I stole this this slide from Robbie. But he maintains all intellectual property rights in it. But seriously, this is a graphic depiction of something in the Geotech agreement, the 246, that I'm willing to bet that most of you have not seen in a geotechnical consulting agreement previously, because it was imported from the ConsensusDocs model. What we've tried to do in ConsensusDocs is to, again, have a fair and balanced contract that promotes the best interests of the project and that promotes best practices in the industry. And for that reason, we have carried over into the 246 this model for resolving disputes that I suspect is far more complex, but yet designed to create a simpler, more efficient result than what you are accustomed to seeing in geotechnical consulting agreements. Most geotechnical consulting agreements, or any consulting agreement for that matter, that I have ever seen, probably say little or nothing about dispute resolution. That is no guarantee that that you will not have disputes. It only means parties have not agreed on what they're going to do to resolve those disputes, and in fact probably condemns the parties to the most inefficient, form of dispute resolution, that being litigation. Another thing I learned early in my career is that construction litigation is a little bit better than dueling, but it's probably not the best way, and certainly not the quickest and most efficient way to resolve construction disputes. What we have built into the 246 is what might be called a phased approach to dispute resolution. We begin with a contract which we believe, first of all, addresses all of the key elements that need to be addressed. Now, you're going to have specific projects that may have unique features that require the contract to be expanded to address issues not addressed in the 246. But for the most part, we have in the 246 addressed the issues that need to be addressed. We've not left things to the imagination, and we've tried to address those in a fair and balanced way. So starting out with a realistic risk allocation is a critical first step toward preventing disputes. Now, while you can prevent disputes, there is no guarantee, or you can prevent some disputes, and you can minimize disputes, there is no guarantee that you will be able to completely avoid them. So the next step in the process, if a dispute does arise, is to, lo and behold, let the parties negotiate, talk to one another, and attempt to resolve those. In my opinion, one of the major advantages of ConsensusDocs over its primary competitor is that it embraces this idea of the parties talking directly to one another in an effort to resolve disputes. You'll see in 8.2 of this contract a provision that actually creates an affirmative obligation on the part of the parties to try to resolve any disputes through direct discussions among themselves before you resort to any third-party dispute resolution mechanism. Now, if that doesn't work, then you go to the next step, which is the same next step that you see in other ConsensusDocs documents, which is some form of non-binding dispute resolution, but with the introduction of a neutral third party, whether that's mediation or what the document refers to as mitigation. And only if that fails, then do you resort to some sort of binding dispute resolution process where you put your fate in the hands of a third person, in other words, where you let someone else make your decisions for you because you're unable to resolve them on your own, the parties. And that can be either arbitration or litigation, depending on which avenue the parties select. Now, a cynic would say that by adding these additional steps, we have increased the time and cost necessary. But obviously, the reason for these steps is to try to resolve the dispute at the lowest, least cost, and soonest level possible, so that the parties can minimize the disruption, the ill will, and the attorney's fees and costs incumbent with the dispute resolution process. So again, it's a much more detailed, Article 8 is a much more detailed dispute resolution procedure than you would typically see in a consulting agreement of this nature, but we do think that's for good reason, and it is consistent with the ConsensusDocs approach. Anything you'd like to add to that, Bob?
No, I think, if it can be translated into matrimonial use, it would be good as well. But, the steps are laid out with this, it may not be a quick and simple solution, but it does give, my regard, I think, if, the second step is, most important to me, that, hopefully it can be resolved on a, sort of a personal level between the owner and the consultant, and, and then if it cannot for whatever reason, then you have, the inevitable, further steps that you have to take. But it does give a very good foundation to how things should be resolved, and it's a very well thought out process, and I think it holds well for what the context of what we're trying to get to contractually tie up.
All right, let's go to the next slide and Robbie then.
Actually, Currie, could you flip back to that first slide? Yes. I just wanted to point out the color scheme is significant here, and that is in the green, if you can't resolve the dispute through negotiation, you've got a green light to take it up to the next step, to take it to a mediator. However, before you go to that last step, the third step, which is a red light, the point is stop, think about it, because once you give a third party, whether it be an arbitrator or a judge or the jury, the right to decide your dispute, once you've done that, you lose all control to make the decision yourself. So you want to keep in the green so that you keep control of your disputes. Okay, Currie, we can go on and now talk about attorney's fees and costs. We mentioned on the last slide that there's a fee shifting provision in the consensus docs, and it is in all consensus documents now. And Phil did mention this. First, 8.5 allows the parties to choose between arbitration and litigation. It used to be that most industry form contracts provided for arbitration as the preferred method of dispute resolution, and unless an affirmative change was made to the contract, parties found themselves in arbitration. Under this contract, you've actually got to select between arbitration and litigation, and if you don't make the selection, then you're going to be in litigation. But what we want to talk about is the prevailing party provision. And what that provision says is that the dispute decider, whether it be the judge, jury, or otherwise, will determine the cost that the non-prevailing party will pay to the other party, meaning the loser is going to pay for the cost of the dispute resolution as decided by the judge, jury, or whatever. Why is this clause in here? Well, the belief is that clauses that provide for loser pay foster settlement. We could spend hours debating that back and forth. I will admit that I at one point was on the side of no, these clauses don't promote settlement. What they do is they encourage litigation because parties are going to think they're going to get their fees, and in the end, that they dig in their feet and they don't settle because of the prevailing party clauses. After considering it, the issue, and reading quite a bit on it and doing some studying and talking to some pretty bright construction lawyers, I think I'm changing my position. I think these provisions are good and they're effective at getting parties to settle cases. There are some things that both lawyers and their clients need to think about when they're using these clauses. One has to relate to the issue of professional liability, which is particularly important when dealing with consultants who will be covered most likely by a professional liability policy. There are professional liability carriers, I am told, I have not seen any cases, but I'm told this is in fact the case, that many professional liability carriers are taking the position that under a clause that shifts fees such as this, those fees are not payable out of the professional's liability policy for the reason that the fee obligation did not arise out of the malpractice or the professional practice of the professional, but rather arose out of a contractual obligation they voluntarily undertook. So if you're a consultant, if you're representing a consultant, and you're going to enter into a contract which has a fee-shifting clause, you want to check with your carrier to find out whether those fees would be covered. Another thing to keep in mind about fee-shifting clauses is that they can create a false sense of security that you will never pay legal fees if you are in the right. The reality is that these clauses only come into operation at the end of the case. So from when the point that the dispute starts until it is resolved either by judgment or settlement or otherwise, you're going to be paying legal fees. And there is no guarantee that simply because you paid a fee to your lawyer and you won the case that the other side will be obligated to pay the entire fee to you. A fee recovery is rarely 100%. More often than not, judges are required to, and many arbitrators do, when they make these decisions on fees, is they determine what is a reasonable fee. Now, of course, we attorneys think all our fees are reasonable, but judges often forget what it was like to practice law, and at times they've disagreed. In a very recent example in New York, in which a plaintiff won a summary judgment, it was an issue of someone had put down a deposit on a very expensive condominium, decided to back out. The contract provided that the deposit, which was several $million, I think it was close to $5 million, would be forfeited if the purchaser didn't go through with the sale. After litigating it for a while, the court determined that the purchaser had no right to back out of the sale and forfeited its entire $5 million deposit it had placed on the condominium. It then came time for the court to determine how much money the condo seller would recover in attorney's fees. Its attorneys submitted a fee request for $3.1 million. The judge, considering it, awarded $475,000, quite a difference. The judge called the $3.1 million fee request breathtaking and determined it wasn't reasonable. So the moral of this story is, before you recover it, you got to pay it, and you probably won't recover everything you paid. Finally, let's talk about venue. The clause in this contract, which is typical to the ConsensusDocs family, is that the venue of the dispute resolution will be the project location. A practice pointer: if the project is in a very remote location, far away from both the owner and the geotech consultant, you might want to rethink the venue provision and place it in a more convenient place. We can move on to the next slide.
Thanks. And Article 9, which I will address briefly here, is the last article of the agreement, with the sole exception of Article 10, which is the miscellaneous provision. And this is the last topic we will address today before throwing it open for questions, to address any questions you may have presented. So let me be rather brief. This is also a provision that you may not see in a lot of custom geotech agreements or consulting agreements of any type, but again, it is consistent with other ConsensusDocs documents, and we think it's fairly important. 9.1 within Article 9 gives the owner the right to suspend the consultant's work for convenience. In other words, even though the consultant has done nothing wrong. And there are a number of reasons an owner may need to do that. We talked earlier about hazardous waste. Certainly if you encounter a major unknown problem on the site, there might be a need to have the consultant stand down while that problem is remediated or addressed in some fashion. And this provision gives the owner the right to do that without requiring cancellation of the contract. It does come with it a responsibility to perhaps pay the consultant additional cost if the consultant does incur additional costs by reason of the suspension. 9.2 addresses termination, and unlike most custom contracts you will ever see, it is a mutual termination provision. It gives either party a right to terminate the agreement in the event of a material breach of the agreement by the other party. And then finally, 9.3, which is a topic that is somewhat controversial at times, which is the owner's right to terminate for convenience. That is a subject that has received a lot of debate in the discussions surrounding other ConsensusDocs documents, such as the subcontract 750. But here, what we have included in the geotech agreement is the right of an owner to terminate the contract, again, even though the consultant has done nothing wrong. Now, we recognize that there could be a cost of that to the consultant, and particularly if you have a limited amount of resources, the consultant has dedicated his resources to this project instead of another project, and all of a sudden the owner gives them 7 days notice that they're no longer needed here, the consultant may not be able to redeploy its resources immediately and make up for that, and therefore the consultant is damaged even though the consultant has done nothing wrong. We recognize that. We recognize that that is another situation that can vary significantly depending on the circumstances. So what we've built into 9.3 is yet another fill-in-the-blank provision that allows the parties to negotiate and agree upon a premium, a termination premium, if you will, that will be paid to the consultant if the owner elects this opportunity to terminate for convenience. Now, the parties are free to insert 0 in that blank if that's what they agree to. But the idea is to make it a topic to be addressed on the front end to avoid a dispute on the back end. I would maintain, even if I were representing the consultant, that there is an advantage to a termination for convenience, because in the absence of a termination for convenience, if the owner has a compelling need to terminate the consultant's performance, such as a lack of funds or a change in circumstances or delays occasioned by other contractors or other events, in the absence of a termination for convenience clause, the owner is forced to declare the contract consultant, in this case, in default, which I don't think behooves either party. So we have built the T for C, as it's commonly referred to, a termination for convenience, into this provision, but we've got a fill-in-the-blank premium there to allow the parties the flexibility to attach a price tag to that if they choose to do so. Bob, anything you wish to add to that before we address any questions we may have?
No, I think at least having the premium, you know, it usually isn't seen, and you know, it makes sense, you know, specifically for, you know, if you do have, like you stated, Phil, before, you know, a smaller consultant may not be able to, you know, jump somewhere else if, you know, they are terminated. So it is, you know, it's a nice, you know, thing, additional thing to have, you know, if needed.
Okay, and I think that concludes that slide. Carrie, do we have any questions that we need to address?
We do have a couple of questions. One of them is, should owners agree to limitation of liability clauses?
I think limitations of liability clauses are becoming a fact of life. I think that the professional liability carriers are looking for them. In the case of consultants, the reality is that if you're going to recover something as an owner from a consultant, it's probably going to be what's available under its professional liability policy. As Phil indicated, a lot of these consultants don't have lots of assets that could satisfy a judgment, so what you're going to be limited to is the professional liability policy and what's available. So I don't think there's a real downside for an owner, and the owner could also negotiate its own limitations of liability. So I don't think they're a bad thing.
Yeah, this is Phil. I'll play devil's advocate to that to an extent. I would not out of hand reject the notion of a limitation of liability. In fact, for all the reasons Robbie said, I think a reasonable and appropriate limitation of liability is probably a good practical thing to have, and if it's high enough, it probably doesn't even cost the owner anything other than some false sense of security. The downside I see, and the way the front question was framed, the reason I feel like I need to give the other side of the coin is that I see a lot of times the owners rely upon a consultant to prepare and provide its own contract, and this kind of circles back to where we began of the purpose of this document. I think in the absence of a good industry form like this, a lot of owners will rely upon the consultant to prepare the form, or will simply sign the consultant's proposal letter, and a lot of those agreements and proposal letters will limit the consultant's exposure to something that is artificially, in my view, low, you know, such as $50,000 or $100,000, or perhaps the amount of fees. I see a lot of contracts that say the consultant's exposure shall be limited to however much they're paid in fees. Of course, the problem with that is if a consultant does perform poorly, they can cause the damage far more they can cause the owner far more in damages than the amount of their fees. So I'm not opposed. I agree with Robbie. I'm not opposed philosophically to the idea of a cap, but I think a lot of thought needs to be given to what a reasonable limitation would be. There's also, I'll just throw this in as food for thought for the lawyers in the audience. There is some case law out there that suggests that a limitation of liability, particularly an arbitrary and artificially low limitation of liability, is in effect an agreement to indemnify, because by allowing the consultant in this case to disavow responsibility for the implications of their own conduct, you are in effect requiring the other contracting party to indemnify that consultant for their own negligence. So some clever lawyers have made the argument that that type of limitation is a requirement that you indemnify the other party for their own negligence, which, as Robbie said earlier, is kind of counter to the principles underlying ConsensusDocs.
Great. We are at 3:30, but we do have another question. So those of you that can stay on the line, great. If not, like I mentioned earlier, we will be sending out a link to the recording. Our next question is, while it might be preferable for the owners to contract for the geotechnical services, in reality, especially on fast-track design-build projects, the design builder is often the party that contracts with the geotechnical firm. Is there any guidance available to modify this form so that it can be used for a contract between the design builder and the geotechnical firm?
I'll take a quick shot at that. The short answer is no. We don't at current have a document would be a construction manager geotechnical consulting agreement, but it wouldn't surprise me to find that there are other folks that feel the same way the questioner did, that there's a need for such a document. And I will say that in other areas, ConsensusDocs has been quick to follow on the heels of a successful document a permutation to address another specific need, and that may be just such a need.
Looks like you have a new assignment, Currie.
Yes, yes, exactly. One last question here, I think, if you have time. If there is a limitation, is it only for a claim from the owner? What about third parties?
That's a very good question, and it goes to what Phil mentioned. When I negotiate limitations of liability clauses, let's say on behalf of an owner, and in fact I just did one with an architect, I accepted claims by third parties for personal injury, property damage, and death, so that it's just direct claims. Another way would be limiting to certain breach of contract claims. So it's up to the attorneys how they draft the clause, and as Phil said, you got to be careful drafting them. There's a fairly recent case out of the New York Court of Appeals in which a contractor determined that if it continued with the performance of the work, it would lose multiples of what it would be liable to under the contract to the owner if it simply walked off the project. And it intentionally walked off the project, intending to limit its liability to the figure in the contract. And the Court of Appeals said that was what was bargained for, and it was valid and enforceable. And the fact that it was intentional was of no moment. So it's something you've got to think about.
Well, I want to thank you, Phil, Robbie, and Bob, for a very informative presentation, and thank you to our participants for joining us today. We really hope this webinar helps you learn a little bit more about contracting for between owners and geotechnical consultants, and can help you with your projects. ConsensusDocs are the only standard contracts written and endorsed by 38 leading design and construction industry associations. Every ConsensusDocs contract was crafted and reviewed by a team of professionals with hundreds of years of practical experience representing all stakeholder interests. Should you need additional information on ConsensusDocs, please feel free to visit our website, give us a call, or send us an email. This brings our program to a close. I hope you all have a wonderful afternoon. Thank you so much.
Thank you all.